man discovered more than $1,200 in unauthorized charges on his bank statement, tied to an upscale hotel where 2 rooms were booked under his name. Bodycam footage documents what followed. Hotel records showed a one-night walk-in stay, paid by card, quietly extended online the next morning. The classic signature of a stolen card being used for as long as it kept working, prompting the front desk to call police to investigate. Unable to confirm which room the suspects occupied, officers split to cover both stairwells before making contact. A standard containment tactic used when a suspect's exact location inside a building has not yet been confirmed.
Basically, the card was used to purchase room 432 and room 440 up under his name. This guy is not here. He called and noticed that the charges were done on his card. And basically, he contacted the hotel to let him know that he's not here and he didn't authorize any charges to be on his room. These are the rooms that they're renting, possibly 2 people per room. Thing of it is, like I said, we're not sure if they're here or not, you know what I'm saying? So as soon as I was waiting on we get some other officers, we can probably go there.
Is that his phone number?
This is the guy here, Miller's phone number.
Miller, so that's just... Okay. Called here and said that his credit card was just used for 2 rooms in the hotel.
Correct.
Or there was a charge on his card.
Yep.
Okay.
So I would assume that they're probably here because they extended their stay this morning online. So
They did it online.
Yeah.
So they were already here.
they did a walk-in reservation at first and then extended their stay online. So it was originally one night. Now they're staying again tonight.
So was the original charge on the same card, or was it?
Yep.
Okay. And so they walked in and had a card when they walked in. Okay. Do you have the information for the guests of that room?
Yes.
So when they come in, they don't do the ID card?
No, they do, but so sometimes they'll have like a fake ID, sometimes they'll have an ID that matches the card.
Yeah, with that person name.
Yeah.
What I want to do is while y'all go and check I'm gonna stand by the other one. So they should be down from each other. So they made some contact and try to run out, they come into me.
Yeah, she do. They got the hell on quick. They ain't even get their bra or nothing. They can see. 2 police cars right there.
They just left.
Mm-hmm.
Check the other room real quick.
Yeah.
All right, here's the deal. Nobody's in the rooms.
Oh,
No, so we need those rooms locked off to where they cannot get back in. If you can do that
yes.
remotely, or if you need to send somebody up there with a key to change the...
Nope, they can't get back in because we made new keys for you guys. So, yeah.
Okay. I just want to make sure that's the first step, is making sure that nobody has access with the keys that were given prior.
Okay.
Hey, can we talk to you over here, please? We just trying to figure out some things too. We just gotta ask you a couple questions, okay? All right. So the reason why we're here is they're saying that whatever card or ID you are using is fraudulent. I'm just getting to the point.
I can get cash and bring that back.
Bring what back?
Like money for my room.
No, so do you have the card or whatever you used?
I had a phone that didn't have tap on it.
No, where's your ID at? First, let's figure out who you are. Who are you?
I gave them my ID.
They have your ID? Mm-hmm. They have it right now?
I believe so.
Where's your ID? You don't have her ID?
For identification, because we're talking about a better approach. I don't know. Am I going right here? Hold on. It's okay. Let's get your ID. No pressure. It's just a simple conversation. Okay, your name is Jessica J. All right. just a second. I'm gonna ask him these two on the note. Okay.
No. That's not what she showed them that first.
Are you booked under a room for your name? Because she said they don't have a room with you or your name.
No, I used my
You use what now?
sister's, like,
Your sisters?
yeah.
Okay, where is that? Can we see that? Whatever you presented to them, can we see that?
Rather than force entry into an uncertain room, officers had hotel management deactivate both keys tied to the fraudulent booking, rooms 432 and 440, denying re-entry without breaching a single door. The tactic worked. Not long after, a woman approached guest services asking for a replacement key to one of those exact rooms, walking, without realizing it, straight into the investigation built around her. Officers asked her to step aside and answer questions. Under Florida versus Bostic from 1991 and INS versus Delgado from 1984, this remained a consensual encounter, not yet a seizure. Asked for identification, she offered to pay cash instead. Answering a question no one asked. That kind of non-answer under pressure reads as evasive to a trained officer and deepens scrutiny rather than resolving anything. The story then shifted, first her own identification, then her sister's, named Amanda Gail. A booking under one name and a person present under another gave officers specific, articulable suspicion of ongoing fraud. That fact pattern satisfied Terry versus Ohio, decided in 1968, which allows a brief investigative detention once an officer has specific facts, not a hunch, supporting reasonable suspicion of a crime. She then said she would not speak anymore and turned to leave, repeating, "Go ahead and detain us," followed by apologies, an attempt to physically disengage rather than simply invoke her right to remain silent.
Is there a code 1 on her or no? Do they have any code 1s on her?
So this is your sister, Amanda Gail?
I need my turn.
Huh?
I don't want to speak anymore.
Yep. I mean, if you don't mind me asking, we're just talking to you. Why don't you want to speak? You said if you're using your sister's name to get a room, I get it. But we're just trying to understand.
I don't.
Okay. Yeah, you're about to. So just stay here. Yes.
Hold on, wait a minute. Yeah, go ahead, detain her. All right, go ahead, detain her. Go ahead, detain her. Go ahead, detain her.
That's not a good idea.
Like, where are you going, man? You're not free to go.
It doesn't matter. You're talking to a police officer. You're not free to go.
You have the right to remain silent. Anything you say can be abused and issued before the law. You have the right to speak to an attorney. You have the attorney present here any question. If you cannot afford an attorney, we'll be provided for you at the government's expense. If you do decide to answer our questions at any time, you can stop answering questions if the question will be present. Do you understand your rights? Okay, knowing your rights and you want to talk to us.
Alright, so now I'm just trying to get like the physical copy of the card and stuff. So basically she's using somebody's account.
Yes, James.
Yeah, the victim called like, I'm not even at the Kempton.
Yep.
So I just need, they've been busy. I just need like a picture, photo ID or something.
Okay, we go ahead and take it to the car. What do you mean you may have things on you?
In the back, in my purse.
What's in here?
Just like
Well, I need
things that
to know.
I don't need to have in.
Okay, well, I'll search. All right, well, we'll see. I gotta search it real quick.
Oh, you gonna search it?
Stay right here. I still gotta search it before you get in the car. Anything on you that you need to tell me about before I find it? What do you have in your bag?
California versus Hodari D. from 1991. Marks a seizure at physical force or submission to authority the moment officers said, "You are not free to go." That line was crossed with no ambiguity left. Miranda versus Arizona from 1966, and Berkemer versus McCarty from 1984 confirm the warning attachés at custody, not at ordinary questioning. It was read here in full, immediately. A lawful custodial arrest carries its own search authority. Chimmel versus California from 1969 and United States versus Robinson from 1973 permitted the bag search without a separate warrant. That search turned up alcohol, a phone, an iPad, and foil consistent with drug use. Evidence that independently supported additional charges beyond the original credit card fraud allegation that began this stop. A second individual, described as having swiped the stolen card and driven the vehicle away from the hotel, was never located at the scene and remained at large as of the final footage reviewed for this analysis. In states with a valid Stop and Identify statute, Hibble versus the 6th Judicial District Court of Nevada from 2004 allows officers to require a name during a lawful stop, though this jurisdiction was not confirmed.
You want to tell me, or you want me to go ahead and find it?
I mean, it's drugs.
It's what?
It's drugs.
Drug? What kind of drugs?
I mean, just some things that you put on foil and smoke.
What? I mean, I don't know.
It's blue stuff.
Is it like THC?
No.
Is it?
I have to, yeah, some.
All right, well, I'll just find it. You can put it back. Let me show it. Okay.
That's alcohol? Alcohol peaches?
No, that's good thing. She said she has some.
What is that? New phones and iPads? You got a phone and iPad? You think we should call Apple and see if it's on?
That's more than enough. What is that?
Oh.
It's too much going on.
She was going.
Yeah.
So, my colleague was just telling me that it's another girl.
Is the girl here? Or, wait, who swiped the car?
I went here.
Where's the other girl at?
She probably in the lobby somewhere or in the back of the parking lot because she came in through the back. She's driving the car.
Okay, well. I mean, we got her in custody. I mean, we can't just ride around and just suspect. Like,
So if she comes in, we'll call you guys too.
Yeah.
Because she had 2 rooms.
So which room was she in?
That I don't know. She just asked me for 2 keys, 440 and 432.
She said it's a friend with her too, but I said, I mean, you have her. She said they're gonna call back. What is that?
I don't know what's in the aluminum foil. I'm just gonna package it.
Oh yeah, cause she got that straw.
Yeah, she said some stuff you put on it. She said it's drugs. She said she got the drugs. It's in my car.
What?
My first time.
Drugs? Make sure you don't touch it with your bare hands.
Oh, I already know that.
Sit tight and we'll talk to you in just a moment. I'll allow you to make some calls.
The subject in this case is a United States citizen. But suppose the same situation happened to someone who is not a citizen. The legal picture changes here in ways that are genuinely worth understanding carefully. The right to remain silent and the right to counsel belong to every single person present in the United States, citizen or not. That constitutional protection does not disappear because of immigration status. For a non-citizen, even an arrest or a pending charge like this one can carry immigration consequences separate from any criminal penalty, and the specifics depend heavily on the exact charge ultimately filed. A detained foreign national also holds a treaty right, under the Vienna Convention, to have their consulate notified, though courts remain divided on enforcing it. This is general information, not legal advice. Officers made 2 key decisions, opening with a request rather than a command, and deactivating the keys instead of forcing entry, both of which kept the stop on solid constitutional footing throughout the encounter. The subject's costliest decision was trying to leave after saying she would not speak further. That single movement converted an unresolved stop into a certain detention, not the underlying fraud allegation itself. Lesson 1. Silence is a right with no cost attached. Asserting it early, calmly, and clearly protects a person far better than offering explanations, cash, or shifting stories once pressure begins to build. Lesson 2. Movement is not the same as silence. Standing still and calmly asking, "Am I free to go?" preserves every legal option that walking away during an unresolved stop immediately throws away for good. Lesson 3. Composure is not surrender, and it never has been. It is what keeps a legal outcome resting on the evidence actually gathered, not on a single mistake made out of panic in the first 60 seconds. This case remains open at the time of this analysis. Composure and knowing one's rights do not guarantee any outcome, but they keep that outcome resting on the facts of the case, not on a moment of fear.